So in this video, I want to talk about what impact the Supreme Court's recent ruling in Bruen will have on the California 10-day waiting period that has been found constitutional in the past. So let's talk about this. But real quick before we jump into this video, if you think a waiting period is unconstitutional, go ahead and hit that like button and subscribe. Also, I want to give a shout out to one of the main supporters of this channel, which is USCCA. Through your membership, you get training, education, and self-defense liability protection. So if you carry a firearm, I highly recommend you take a look into USCCA, and I'll put a link to them down in the details section. So like I said in the intro, the Supreme Court's recent ruling in New York State Rifle and Pistol Association v. Bruen has completely changed the landscape of Second Amendment litigation. This change impacts not just current and future cases, but also impacts past Second Amendment cases as well. That includes the prior Ninth Circuit ruling on the constitutionality of the California 10-day waiting period. Because of the Supreme Court's recent ruling in Bruen, the Ninth Circuit's prior decision in Silvester v. Becerra is no longer valid. Now, Silvester v. Becerra is a case many of you may not know about or maybe even forgot about because it reached its final resolution back in 2018. This case involves California Penal Code section 26815, which states that no firearm shall be delivered within 10 days of the application to purchase or after notice by the department pursuant to section 28220, within 10 days of the submission to the department of any correction to the application, or within 10 days of the submission to the department of any fee required pursuant to section 28225, whichever is later. Those are the general provisions under California law which require a 10-day waiting period before you can take possession of a firearm that you purchase. The case Silvester v. Becerra was a direct challenge to that restriction in the state of California. Now, after a 3-day bench trial, a district court in the case found in favor of the plaintiffs. In reaching that decision, the court applied what is known as intermediate scrutiny. The district court concluded that California's waiting period was not reasonably tailored to promote an important governmental interest. After reviewing California's studies on the relationship between waiting periods and gun casualties, the district court found that the data was inconclusive. The district court also noted that the studies seem to assume that the individual does not already possess another firearm. California submitted no evidence about subsequent purchasers or subsequent purchase of firearms, which was significant because of a waiting period that they had in place. And they could not prove that it would deter an individual from committing impulsive acts of violence if they already had a firearm in their possession. Keep in mind, the entire rationale of public interest that the state of California put forward for why they needed this restriction was that the state of California needed a cooling off period to prevent impulsive crimes from occurring. But they didn't show that any of this data related to maybe people who already had a firearm. So they had no evidence that this would actually stop something like that or would deter those types of situations. But even if some cooling off period is necessary, the district court found that California made no attempt to defend a 10-day waiting period, and they found that the background check process will naturally create a waiting period of at least 1 day for 80% of all purchasers. The district court also found that individuals who meet California's requirements for a concealed carry license are uniquely unlikely to engage in impulsive acts of violence. So that was another caveat where the state of California's law, the 10-day waiting period, is applied across the board, even to people who are CCW holders who have gone through a more stringent process to prove that they are not prohibited people, but still it was being applied against them. Therefore, the district court found that the 10-day waiting period was unconstitutional, even under intermediate scrutiny. Well, of course, the state of California didn't like that decision, so they appealed up to the Ninth Circuit. And the Ninth Circuit Court of Appeals, on review, reversed the lower court's decision. The Ninth Circuit concluded that the test for intermediate scrutiny from the First Amendment cases applies here to California's waiting period. They stressed in the opinion that the test is not a strict one, they said. The Ninth Circuit held that California's law prevents gun violence by creating a cooling off period, is what they said. Although California studies did not isolate the effect of waiting periods on subsequent purchasers, those studies confirmed, they said, the common sense understanding that cooling off periods deter violence and self-harm, an understanding that is no less true for subsequent purchasers. So the Ninth Circuit found that that gap in evidence between first-time purchasers and a cooling off and subsequent purchasers, they didn't find any issue with that gap in the data. Now, this case was then taken up to the Supreme Court, and Supreme Court certiorari, a review of this case, was sought by the Supreme Court. Now, ultimately, review was denied by the Supreme Court. However, there was a dissent for that denial of cert that was written by Justice Thomas. In his dissent, he stated, "This court has not definitively resolved the standards of evaluating Second Amendment claims. Heller did not need to resolve it because the law there failed any standards of scrutiny that we have applied to enumerated constitutional rights. After Heller, the courts of appeals generally evaluate Second Amendment claims under intermediate scrutiny." He went on to state that several jurists disagree with this approach, suggesting that courts should instead ask whether the challenged law complies with the text, history, and tradition of the Second Amendment. Although Heller did not definitively resolve the standard for evaluating Second Amendment claims, it did reject two proposed standards. The court first rejected the freestanding interest balancing approach, which would have waived the law's burden on the Second Amendment and our rights against governmental interests that the government is saying that they want to promote. The court also rejected the rational basis scrutiny. And in this dissent, Justice Thomas pointed out that the Ninth Circuit has been using a watered-down intermediate scrutiny standard that was more like a rational basis test, which was expressly rejected in Heller and McDonald. But he went on to state that the Ninth Circuit's deviation from ordinary principles of law is unfortunate, though not surprising. He stated its dismissive treatment of petitioner's challenge is emblematic of a larger trend. As I have previously explained, the lower courts are resisting the court's decision in Heller and McDonald and are failing to protect the Second Amendment to the same extent that they would protect other constitutional rights, is what Thomas said. In this dissent on the denial of the cert petition, Thomas clearly stated that he was unhappy with the Supreme Court for continuing to refuse to hear more Second Amendment cases, and that he thought that the continued refusal of lower courts to use the correct standard was also a problem that the Supreme Court refused to review. Well, flash forward to 2022, and Thomas finally got a chance to right all of these wrongs. He himself got to author the New York State Rifle and Pistol Association v. Bruen decision, which actually fixed a lot of these issues that he mentioned in the Silvester dissent. In this decision, he found, "Today we decline to adopt the two-part approach. In keeping with Heller, we hold that when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. To justify its regulation, the government may not simply posit that the regulation promotes an important interest. Rather, the government must demonstrate that the regulation is consistent with the nation's historical tradition of firearms regulation. Only if a firearms regulation is consistent with the nation's historical tradition may a court conclude that the individual's conduct falls outside the Second Amendment's unqualified command." He went on to then state, "Despite the popularity of this two-step approach, it is one step too many. Step one of the predominant framework is broadly consistent with Heller, which demands a test rooted in the Second Amendment's text as informed by history. But Heller and McDonald do not support applying means and scrutiny in the Second Amendment context." And then he expressly also calls out intermediate scrutiny, saying that intermediate scrutiny should never be applied in these types of cases. So what does this mean for the prior Silvester decision by the Ninth Circuit and the California 10-day waiting period? Well, that means the law is now wide open for a renewed challenge using the correct type of standard, which is text as informed by history. The prior decision upholding the 10-day waiting period was based on the two-step approach and balancing of interests, which the Supreme Court said is completely irrelevant and never should be used. Now, in a new case, the state of California will need to prove that there is some historical regulation or tradition dating back to 1791 that restricts a person's ability to purchase a firearm and immediately then take possession of it. That task is going to be next to impossible for the state of California because I am not aware of any law or regulation or restriction back during 1791 that made it so that colonists could not actually go to a store, purchase a firearm, and would have to wait 10 days to take possession of it. So it's going to be a really hard task for the state of California to point to some sort of historical basis for a 10-day waiting period. So I would expect that sometime soon a new 10-day waiting period case will pop up. Maybe a renewed Silvester case or Silvester 2 will pop up because actually, interesting fun fact, the plaintiffs here in this case, Silvester, are both higher ups in the Now Firearms Policy Coalition. So I could definitely see another Silvester case popping up, Silvester 2, essentially going back to the court saying, Ninth Circuit clearly got it wrong. The Supreme Court said that you clearly got it wrong back in 2018, and now you need to fix this issue. So if you guys have any questions, go ahead and comment down below and I'll try to answer the best of my ability. Also, like this video and like support the channel. One of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel algorithms. It adds fuel to his jet and signals to YouTube that you guys see value in these videos and in this type of two-way news. Again, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. And as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this is with Built by Armed Scholars, and this nation will be maintained by armed scholars.